So we've got another major twist in the nationwide challenge to the NFA after the $0 tax changes. The plaintiffs continue arguing that the NFA can no longer survive now that the tax has disappeared, but the ATF may have just complicated that argument with one of its new proposed rules. The ATF is now proposing to loosen multiple NFA-related restrictions at the same time that this litigation is moving forward. And that creates a very interesting legal question going forward, because one of the plaintiffs' core arguments in these NFA cases is that once the tax goes to $0, all that remains is a burdensome regulatory scheme. But if the ATF starts making the process look more like a shall issue licensing system, well, the question is, does that undermine part of the plaintiff's constitutional theory? And really, does it support the ATF's arguments in this case that this simply is a shall issue system? So let's break down what is now developing. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply by subscribing. You can also hit the like button that just tells the algorithm that you appreciate this type of content, and so it shares it with more people. Now, as we've discussed previously, this lawsuit is kind of part of the broader challenges to the NFA after Congress effectively reduced the tax on these NFA items from $200 all the way to $0. Now, historically, the NFA survived constitutional scrutiny because the Supreme Court treated it as a tax statute. And that was always used as the foundation for the NFA. But now the plaintiffs argue that if the tax no longer, really exists, well, then the constitutional justification behind the NFA has completely collapsed. And according to the plaintiffs in these lawsuits, what really remains now is simply registration requirements, fingerprints, approvals, restrictions, and also potential criminal penalties. And that exists all without a legitimate taxing function. And recently, the plaintiffs strengthened that argument even further by introducing new Fifth Circuit authority, which suggests that laws not generally tied to revenue generation cannot be actually constitutional. They cannot survive under Congress's taxing powers. They have to generate some type of revenue. Some sort of money has to be collected for it to be considered part of the taxing powers. But now we have another major development layered on top of all of this. At the same time this litigation is unfolding, the ATF has introduced multiple proposed rules which aim to loosen parts of the NFA process itself. For example, the ATF is now proposing to completely eliminate the CLIO notification requirements for the NFA applications. Right now, the applicants still have to send copies for their forms to local law enforcement agencies. The ATF now says that requirement failed to produce any meaningful public safety outcomes and should actually be removed completely. The ATF is also proposing to relax the interstate transportation requirements for these NFA items. And historically, owners often had to seek advance approvals before crossing state lines with certain NFA items. With the new proposed rules, the ATF appears to be moving towards allowing temporary interstate transport without advanced approval in certain situations. And beyond that, the ATF is generally trying to modernize the process of the NFA through expanded digital systems, streamlined paperwork, and simplified administrative requirements. Even the whole serialization component is also going to be getting an overhaul. Now, this becomes legally interesting because one of the plaintiffs' major arguments in these lawsuits has essentially been that the NFA is no longer functioning as a tax system, and instead it operates as a restrictive regulatory scheme. But these new ATF rules potentially allow the DOJ to argue something different. The government could now argue in these cases that essentially, look, this is not some arbitrary discretionary prohibition system. Instead, they may argue that the NFA increasingly functions more like a predictable shall issue permit system. And that matters because courts tend to view shall issue systems differently than systems involving these types of broad discretionary denials. And also, shall issue schemes are one of the things that were mentioned by the Supreme Court in Bruin. In some jurisdictions, some states, and also the federal government have been trying to lean on shall issue systems to argue that if they operate objectively, if there are no discretion involved, if it just has a system in place that you apply for, you get it, and there's no discretion, well, then they argue under Bruin that is permissible. Now, to be clear, the plaintiffs are still making a very serious constitutional argument in these NFA cases. They're arguing that the taxing power itself is collapsing and that the whole NFA justification has now gone away. But the DOJ may try to shift the focus away from those burdens and towards the whole shall issue process. In other words, they could argue that the NFA system is still becoming more ministerial, than restrictive, and the government could point to things like the Clio notifications, the transportation restrictions being loosened, the digital modernization, and all of those things that now support them trying to say that this is a shall issue scheme. And that could potentially blunt some of the plaintiffs' arguments that the system is simply an unconstitutional web of restrictions that is now surviving without taxation. Now, importantly, this does not automatically defeat the plaintiffs' arguments because one of the core constitutional issues is still in play, and that revolves around the taxing powers. The Fifth Circuit authority that recently was submitted by the plaintiffs, points to this fact, and it attacks whether laws that are disconnected from actual revenue generation can survive under Congress's taxing powers. So even if the process becomes smoother, the constitutional foundation may still be very vulnerable. And really, there's another way to look at this as well that the plaintiffs could try to use in their favor. Some of the plaintiffs may argue that this new ATF rule, that all these new NFA changes, actually reinforces their position. Since the ATF is steadily removing some of the NFA regulations and the tax is also now gone on all of these types of items, well, then the NFA, as originally passed, really no longer is in operation. It does not look like the same type of law that was passed by Congress. So in other words, the more that the ATF modernizes and streamlines the system, and now that the $0 tax is in place, it starts to look like the NFA is not needed at all, and the original law that was passed by Congress really doesn't even exist anymore. So the plaintiffs could try to use the new changes with the proposed rules to point to the fact that the NFA should just be completely struck down. And what this really shows is that the legal fight around the NFA is currently evolving. Originally, the challenge focused heavily on the $0 tax changes itself, but now the debate may start to shift towards what exactly the NFA has now become with the new rule changes that were put in place by the ATF and also the $0 tax that was passed by Congress. The question becomes, is this still fundamentally a tax law, or has it evolved into something much closer to a standalone federal licensing scheme or a registration scheme, or really is this even needed at all, or is this something completely different than what Congress originally passed? And that is a question that the court will now have to address in this case based on the new ATF proposed rules and also the law that was passed by Congress. So that's the latest with the ATF kind of rule package and how that may end up actually impacting some of these $0 NFA tax lawsuits that are moving forward. And all of this is now likely going to be submitted to the court, and there's going to be arguments back and forth about what these ATF changes may do actually for this lawsuit. So as we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.